Yes, my lord, I am praying for listing of one read petition, my lord, unlisted item, my lord, at 2, my lord, for withdraw with liberty, my lord. Obvious.
Right. So, Lordship, I'd like to mention item number 16 on behalf of Mr. Tony Patil. He has left Itanagar due to some urgency. He has requested to post this matter after Bihu break.
Okay. Both sides are
16.
represented. Both sides are represented on the prayer made by land council for the petitioner. Just after ensuing new petition.
Obliged.
I would like to mention item number 7 for adjournment.
17.
7.
Only 7. Okay.
On behalf of Doya Joji. Matter will be taken after 1 week, Your Honor.
Just a moment. We required some instructions here. Just wait for some time. Just wait for some
Your
time.
Honor, I have conveyed the other side also.
No, but I think some instructions was required. Just show us item 7. Okay. On the prayer made by land council for the petitioner, just after.
C. Peter.
No. How much time you want?
Pardon?
Adjournment for how much time?
1 week, Your Honor.
Just after a week.
Lordship, I like to take adjournment of the item number 31 and 32, Lordship, today's supplementary hearing.
This is hearing matters.
Yes, Lordship. Lordship, actually, where Lordship, there's private respondent in this matter, Lordship, correspondent number 2, where they has to Lordship file affidavit, Lordship, in reply. So Lordship, they has not turned up till that, Lordship. So Lordship,
This is a criminal petition.
yes, Lordship. So Lordship, actually, yes, Lordship.
Respondent number 2, you say has to file an affidavit.
Yes, Lordship. Because Lordship, he said at that time he was posted dear Lordship, and he is the complainant, Lordship. So he spoken to me that here I have to file. He spoken me to file affidavit on his behalf, but his name is reflected in item number 2, Lordship. So some more time to Lordship, so that whether he file himself or Lordship through me, Lordship, he wants to file in the affidavit. So some more time may be given, Lordship.
Both sides are represented.
Lordship, there's an interim in both the matters.
On the prayer made by the
31 and 32, Lordship.
you are appearing as PP.
Yes,
Yeah.
Lordship.
Ms. Lavilla, PP, the matter is adjourned today, just after receiving the petition. Interim order passed today, stands extended till the next record listing. Okay.
Much obliged, Lordship.
Lordship, I, on behalf of the Learned Standing Council for the Department of Health and Education, beg to mention item number 16, 17, 18, 20, and 25. 17. May I correct myself? 16, 18, 20, and 25.
18, 20, and 25. 20.
Yes.
Why 20?
Lordship, in item number 20, there is a hurry, Lordship, pension matter. Item number 20 is a pension matter, Lordship.
I think 20 is a pension
Lordship,
matter.
education has no role to.
Okay. 20 will take it up.
Yes, Lordship.
18 and 20.
25, Lordship.
25. Okay. 16 is already adjourned. 18 and 25.
In that case, Lordship,
Both sides are represented.
18 and
Made by an understanding of Standing counsel for the health department, the matter stands adjourned today. Just after answering the petition, review petition. Item 20, we'll take it up. Yes, next.
Please, Lordship, I beg to mention item number 17, Lordship. Lordship, this matter has become in process, Lordship. Kindly, I may be allowed to withdraw this matter, Lordship.
Pardon me, I did not get it.
Lordship,
You are paying for on behalf of?
this OP,
Okay,
17,
what says the representative on the prayer made by Learned Counsel for the petition?
17.
Let's start answering your occasion. Okay,
Obliged, Lordship.
Your Lordship, I would like to mention item number 30. I'm on behalf of Learned Counsel G. Talo for the respondent number 2. Your Lordship.
this is 2020 matter, we are not adjourning it.
Lordship, we need some more time for the hearing.
Let me look at the record because it's 2020 matter. Renew the prayer when the matter reaches.
Okay.
Renew the prayer when the matter reaches.
Yeah, Lordship, I would like to mention item number 14 for adjournment
14.
for today. As the leading counsel is out of station.
Okay, same order, item 14.
Obliged.
Your Lordship, I beg to mention item number 13. I'm for the petitioner and I'm appearing on behalf of conducting counsel Takam Sunil. Your Lordship, the conducting counsel's health is not well, so this matter may be listed after 2 weeks. I have informed the opposite party as well. And Your Lordship, there is an interim order which may be continued.
Indian order passed to this, trans extended to the magistrate of this time. Okay,
Deeply obliged.
yes.
May I, Lordship? Lordship, I beg to mention item number 22, Lordship. I may be allowed to withdraw this petition, Lordship.
Item
22, Lordship.
22.
Lordship.
Okay, what says I represented on the upon instructions for Mr.
K. Lawlin, Lordship.
A.
K. Lawlin, Lordship.
K. Lolan,
No.
Learned Counsel for the petitioner, seeks to withdraw this writ petition. Prayer is allowed. Matter is dismissed on withdrawal. Is there any interim order operating?
No, Lordship.
Okay.
Lordship, one more item, Lordship. I beg to mention
Matter is
writ
dismissed
petition,
on withdrawal.
writ petition number 358, Lordship, for listed for Monday, Lordship. It's for also for withdrawal, Lordship.
Okay.
My Lordship, I beg to mention item number 11. Lordship, in this matter, was supposed to file affidavit. However, we need some more time to file. Therefore,
Who is to file affidavit?
petitioner,
What sort of affidavit you want in a criminal petition?
uh,
It's a criminal petition. What
Yes,
will
Your
affidavit do there?
yes, Your
In a criminal petition, why is the affidavit required?
Lordship.
My lord, actually what has happened, they file a criminal petition annexing a settlement deed. And that settlement deed, they have referred to a Kaba decision. So considering that aspect, the court has directed them to produce the Kaba decision as well as the settlement deed, your lordship. To produce both the settlement deed, as on that they have not filed it, your lordship.
Okay. What says the representative on the prayer made by Learned Counsel for the petition? This is adjourned. List after 3 weeks. Okay.
Obliged, your lordship.
May I, Lordship? Lordship, I beg to mention on unlisted GST matter, which was listed on 2nd of this month. Lordship, I may allow to make some clarification regarding last order which was passed on 2nd of this month.
I don't get it. Please repeat again.
Lordship, I may allow to make some clarification regarding the order which was passed on 2nd of this month.
What is the mistake? Just show it to us.
Lordship, impugn order which on annex in annexure number 3, it is reflected as Superintendent Daporizo. But however, Lordship, cancellation order is system generated and it is only based on business, place of business where petitioner is running his business. And Lordship,
You have a copy of your petition?
yes, Lordship.
Look at the impugn order, who has passed it? And who is the respondent?
Lordship, kindly come to left corner of impugn order, which is annexure number 3. There it is clearly mentioned Itanagar range, wherein in support I have submitted one more documents regarding the jurisdiction of range.
Okay, allow it. Okay, allow me to mention now.
Okay.
Yes, next.
The Lords, I beg to mention item number 28 on behalf of M. Kato to list it after 4 weeks. 28.
You have taken consent,
Is
but why it has been listed by orders?
to file affidavits, my lord, to file affidavit.
No, somebody has made a mention, that's why it's listed on orders. You can't adjourn it like that.
My lord, it is for filing affidavit, my lord.
For
So we
filing
don't know,
affidavit.
somebody has made a mention, that's why it's come by orders. You wait till the matter reaches.
My lord, in item number 8, my lord, I have in petition I have made a clerical mistake, so trying to withdraw with liberty, my lord.
Item 8,
8.
okay,
So
your name,
date has been
your name,
Odugong.
or Dugong. Okay. What says it represented? Upon instructions, Mr. Dugong, then counsel for the petitioner submits that a clerical mistake is has been advertently made in the petition, and therefore seeks liberty to withdraw the same and file again. So there is the matter stands dismissed on withdrawal with liberty as paid for.
Obliged.
Yes, my lord.
My lord, the accused person is arrested on 17 to 2025. Yes, my lord.
Okay,
The applicant,
You call for the case diary.
yes, my lord.
Your Lordship, FIR is in page 15.
It's okay, you produce the case diary.
Yes, Your Lordship, call for the
When?
case there, yes.
When?
Your Lordship,
11.
Your Lordship, let it be on 11th.
11, make it 10th.
Okay, Your Lordship. Okay.
It's okay, produce the case diary.
Yes, Your Lordship, call for the case there.
When? Okay, with the The case diary we produced on 10/4/2025. Yes, sir.
Obliged.
Just a few matters here.
This is also a Your Lordship regular bail application. Applicant side is Your Lordship not represented to me.
No, that's okay. This is 105 is.
Attempt to murder, or Your Lordship, culpable homicide not amounting to murder.
Culpable homicide. Okay.
Yes, Your Lordship.
Let the case diary be produced on. This is from which place?
Your Lordship, this is from Siantajo, Your Lordship.
Yes.
Sepa, West Caming district.
It will take some time.
Yes, Your Lordship.
It is produced on 22/4/2025.
Yes. Deeply obliged.
This say none person call for the petition.
May I please, Your Lord?
Just
Your Lordship.
where's the FIR?
Lordship, FIR is at page 18, Lordship.
You have to call for the case diary.
Lordship, interim.
No. You have first the signature of Deputy Commissioner.
Lordship, here, Lordship, I am not named, Lordship.
We don't
Main
know, but
alleged
once
accused-
once it's a case of forgery of the signature of Deputy Commissioner, let us see the record.
Lordship, already the main alleged accused has been arrested, Lordship, in this
You
case.
don't know, there must be some reason. There must be some reason to. And you,
Lordship, it's a documentary. The whole case will be based on documentary evidence, Lordship.
no.
Already, all the documents has
Signature-
been shared.
Every case is dependent on evidence. Which criminal case is not dependent on evidence?
Lordship. Here, Lordship, the allegation is in regards to forging of a signature, Lordship.
We can't
So-
allow that. Bail without looking at the case diary.
So, in my humble submission, Lordship, his arrest is not warranted in this case, Lordship.
That only the case diary will say.
Lordship, I am ready to cooperate, Lordship.
No. Not when there is a forgery of Deputy Commissioner signature. Did the case diary be produced? This is from which place?
No, SEPA case.
Sepa. It takes some time to reach.
2 weeks will be, Lordship. 2 weeks. 2 weeks will be
Fixed date,
long, Lordship.
21/4/2025. 21/4.
Scan copy, Lordship. This, next week, Lordship. Scan copy with
You have to call for the case diary. Why you need extra copy?
scan copy.
Oh, scan copy.
Yes,
Okay,
scan
okay, okay.
And
I'm
updated.
sorry,
Yes.
I misheard you. When do you want?
Lordship, next week, Lordship. Since it's a pre-arrest bail, Lordship. If he is arrested, Lordship, matters become invexation.
Can't repeat.
So, humbly pray for so dead. Next week, Lordship, any day next week.
case diary or scan copy on 10/14/25. Okay.
Four also it's connected to same,
Same.
and five is some other, PS.
Okay. 5 is from some other place, same case.
Same arising from the,
Same, okay. Same.
outlet.
Yes.
May, my lord.
This is not compoundable case. You have to dismiss your petition.
May, my lord. My lord, kindly see the settlement agreement, my lord.
It's a non-compoundable case.
Yes, my lord. That's why I have a 500, 628 of BNS.
No, it's a offense against the state. You can't compromise.
My lord, till charge sheet has not been filed and SFL,
That we don't know, but
FSL report has not been.
this is not a case which can be compromised. It's a offense against the state. Counterfeiting of note cannot be compromised by two persons.
My lord, till that, since this matter is, FIR was lodged on 2021, my lord, till that, no charge sheet has been filed.
That is for the state. You should be
Yeah.
happy. They have not filed it.
Lordship will call
My
for the
lord,
case diary, Lordship.
Case diary may be
Case
called
diary
for.
may be called for.
What will you do with the case diary?
Lordship,
Tell us. In that
Because,
in that
Lordship, the
question application.
investigation, Lordship.
Yes, ma'am.
If
It is for the state to monitor it. In this criminal petition, why should we take up when the case is for quashing? Why should we exercise our power to monitor the investigation?
Lordship is still, Lordship, in hand power of this court, Lordship. If
Yes.
Lordship deems fit, then it may be otherwise, Lordship.
You see, the state is happy with it. The state is happy with it.
Lordship.
You put your vigilance behind these people. If your officers are not filed, not investigating, what is your vigilance doing? I can't pass these orders in his petition.
Your Honor, CD may be called for. I only pray for. Your Honor, I am a teacher. I am a primary teacher. Government school teacher.
Whatever is there, but it's a case of forgery of what you call counterfeiting of Indian currency notes.
My lord, Your Honor, the FIR is only a mere, only this FIR charge has been only
You
merely.
caught with fake notes, 500 rupee notes.
Only to preliminary investigation, police has make a charge this section, Your Honor.
You see, if I say anything in the order, it will go heavily against you. Because if they have not investigated this, no charge sheet is submitted. Then a fake Indian currency note will ask the CBI to take over. And this IO who is there in the case will be facing music. Madam, we'll only say we issue notice, we say why should the investigation not be handed over to the CBI?
Yes, Lordship.
Yes.
We file a response.
Yes, Lordship.
If it is fake Indian currency notes, then you don't investigate. You file a closure report if there is nothing. We can't allow this to happen. But Mr. H. Lomi,
T Taggu.
I'm sorry. Learned counsel for the petitioner. Next, madam. by filing this application under section 528 of the DNSS, the petitioners have prayed for quashing of the FIR dated. What is the date? 91071? 7/1/2021. Passed, filed by the respondent number 2. Before the officer in charge, Itanagar Police Station, on the ground that the petitioner number 1 was caught with fake Indian currency notes while purchasing a packet of cigarette at his shop. Next, the learned counsel for the petitioner submitted that the complainant and the accused, being the petitioner number 2 and petitioner number 1, have compromised the matter. Next paragraph. Issue notice. Returnable in 4 weeks. Notice is also issued to the state to show cause as to why the investigation of the case should not be handed over to other agencies. If the Arunachal Pradesh Police cannot conclude its investigation in such matters in a time-bound manner. Next, by the learned. Just extra copy of the this petition be provided to the learned AVP. Mr. Raghul and the AVP was accepted notice on behalf of the state. Next one, the learned AVP shall transmit a copy of this order to the jurisdictional superintendent of police. In Itanagar, it is superintendent of police.
Yes, sir.
Okay, so next paragraph, this after, just for that. The learned AVP shall also produce the case diary.
Scan copy of the case diary also.
Case diary or scan copy thereof. Next date of listing. Next paragraph, this term. 28/4/2025. Notice is made on 28. Yes.
But
Item number 9 and 27 are connected matters, my lord. Item number 9 and 27. My lord, what happened, the basic issue is here. My lord, the petitioners before your lordships, they are, my lord, working as extension officer, rural engineering. My lord, their juniors were sent on deputation to DRDA in violation of the office memorandum issued regulating the procedure to be followed in that taking over, my lord, in that sending. Now, my lord, the government of Arunachal Pradesh has issued a, my lord, notification by which the DRDA people were brought back. Now, in DRDA, these people initially got appointed or engaged on deputation as, my lord, assistant project, my lord, TAIWP and TARE, technical assistant, rural engineering and technical assistant IWDP. Thereafter, they were taken over to the next higher pay scale of assistant project officer, rural engineering. Now, what happens is that when they were brought back, my lord, to the rural engineering department, which is their parent organization, they were given pay protection and consequential seniority. Now, what will happen, my lord? Our juniors went to DRDA. They got some higher pay scale there in DRDA. Now they are brought back. We are still EORE in the rural engineering department, and they are getting more salary than us. It's absolutely wrong. If I just take your lordships to the impugn notification, my lord, I don't know what mind they have applied in issuing the notification. Because lordship, lordship will take up item 27 for a moment. That contains the impugn decision.
My lord, item number 27, we have not filed our affidavit, my lord, because the notification, there is some defects, my lord. Now we have put it before the cabinet, my lord, and cabinet is under consideration of the notification, my lord. Soon it will be rectified, my lord. So we will file our proper affidavit, my lord. Because of that, we have not filed our affidavit in item number 27.
No, in fact, that the matter is under consideration by the cabinet.
Yes,
That
my lord.
also an affidavit has to be filed.
Well, because my lord, we want to file a proper and perfect affidavit, my lord, not by my lord, part by part, my lord.
But then we'll have to record your submission, and if that turns out to be false,
No, my lord. We are ready, my lord. We are ready to file our affidavit.
no, you see,
Our affidavit is ready, my lord.
we don't want any officer of the court to be in trouble.
My lord.
If that is your instruction, let that one paragraph affidavit be also filed. Because then,
Yes.
then it is not on you.
Right.
It is the instructions based on the affidavit that you are saying that the matter is under consideration.
Yes, my lord. Some mistakes are there,
No, that's okay.
my lord.
But you see, when the authorities are examined, you don't want us to record that.
My lord, my lord. That item number 27 is in order column, my lord. This is admission, my lord.
Because item number 27 is the consequence of item number 9, my lord. In
It's
item
okay, let
number,
them examine it. If they are saying it is with the cabinet.
what they are doing is that, my lord, they are paying the higher salary, and till now they are paying the higher salary, even after the challenge.
No, because
Well-
if the pay protection is there, they'll have to pay. It will only be consequential remedy that will be available, but the right accrued cannot be taken away.
That's true, my lord. In fact, on the first date, my lord, I insisted for a stay of this input because apparently this is illegal and wrong, because you cannot give a higher pay to a junior in the guise of bringing him back from deputation to the parent organization. Because when you bring him back to the parent organization, he'll have to be equated with the others, seniority and pay.
You should have, the petitioner should have been more brilliant. You should have asked your pay to be at the same level of your
Protected.
juniors.
Correct, my lord. My lord. That is an alternative prayer, my lord. But the thing is, the heart burning is there, my lord. There.
My lord,
Our
our
HK does can transfer to the petitioner.
And in item number 9, my lord, there was an order by this honorable court on 31/1/2024 to the extent that the recruitment rule for the post of assistant project officer, which is the next higher post in the
existing hierarchy in the rural engineering department, they were directed that the recruitment to finalize the recruitment rule. Till date, nothing has been done in that regard, my lord. In item number 9, that was one of the issue, my lord.
Right, so, I should ask my counsel the petitioner. As well as Mr. B. Pichar, I'm standing counsel for the
Rural development.
Rural Development Department. You're agreeing for all the respondents?
In item number, my lord, in item number
Nine,
nine, my lord,
Taking a-
yes, my lord, all the respondents.
All the respondents? Next problem. The learned counsel for the petitioner has submitted that the affidavit opposition has been filed by respondent numbers 1, 2, and 3. Mr. Bhava. In the however, this could be order dated 31/1/2024. Expressed its opinion that the recruitment rules are framed in accordance with law. The principal grievance, which is connected to the first relief, would be redressed. And insofar as other reliefs are concerned, those were kept open for consideration in an appropriate time. So it is submitted that the grievance of the petitioners in relation to the first prayer remains unredressed. Next one, it is further submitted that some person of the rank of the cadre of extension officer
Yes.
within bracket
Extension officer, my lord, within bracket rural engineering.
it's a rural engineering were sent on deputation to
DRD.
DRDA, where they were receiving higher salary, and when they were repatriated to their parent department, the state has granted their pay protection. So accordingly, it is submitted that although some officers like the petitioner are getting less salary, though they are seniors in the cadre. There are several extension officer within bracket rural engineering in the rural development department who are drawing salary higher than the salary anomalies higher than the petitioners. In your affidavit, what you have said with regard to this,
My affidavit, my lord. We say, my lord, the writ petition is not maintainable, my lord. Firstly, my lord, because my lord, for my lord, may kindly see the prayer, my lord. Page 23, my lord.
Rule, so far as rule, they say it's in the pipeline. It will be coming shortly. That is their stand in the affidavit.
page number,
23, my lord, of
number-
the writ petition, my lord.
9 of the affidavit.
Prayer 1, my lord. Issue writ in the nature of mandamus directing the respondents to frame service rules, my lord. It is not maintainable, my lord. This settled law, my lord. The court, my lord, cannot direct for framing of recruitment rules, my lord.
okay, what is the next prayer?
Yes, next, my lord. Issue in the writ of nature of mandamus directing the respondent to consider the case of the petitioner for promotion to the post of APO tax so and so, forthwith or with consequential benefits. My lord, we have a total strength of 9 APO take, my lord. We, in the entire Arunachal Pradesh, we have a total strength of 9 posts of APO take, my lord. So, my lord, beyond that post, my lord, we cannot give them promotion, my lord. beyond that strike post. my lord.
How many posts are vacant right now?
But all are full, my lord. There are total 9 strength, my lord, and all are full, my lord.
Okay, what is number 3?
3, my lord, issue writ in the nature of mandamus directing the respondent to prepare updated seniority list, my lord, before making any promotion to the post of APO, my lord. My lord may consider this, my lord. May direct the authority concerned to prepare a updated seniority list, my lord. We do not have any objection, my lord.
Lord, my first submission is that, my lord, without a recruitment rule being in place, how they will make the promotion? That's why the first prayer. If my right of consideration for promotion is to be taken care of, there has to be a rule. And in the affidavit, they say the rule are in the pipeline, we will do it. And that was in the year, I think, my lord, 2023. Till nothing has been done. Even against the 9 posts, my lord, they have adopted pick and choose manner. And thereafter, what they have done, this DRDA chapter came. They have issued an OM. That OM says that you will take person from rural engineering to DRDA by following a selection process. Without any selection process, they picked up juniors to us who are junior 30 number down to us. They have picked up without any selection process. They have.
That has to be challenged.
Yes.
Yes,
That part has to be challenged.
that has been challenged, my lord, in the earlier one.
Hmm?
Those pleadings are there in the first writ petition that you have violated the OM, your own OM, to take people to DRDA.
Where is, but there's no prayer.
Yes.
Pleadings, prayers are two different things.
My lord, prayer number 2. We said you also consider our case for post of APO RE. APO RE is a post in DRDA. And
This prayer-
technical
this,
assistant RE.
This prayer can't be granted. If the posts are filled up, you will have to challenge the.
No, this is
appointment made to the post.
this is on deputation, my lord. This is not on regular. This APO RE is a post in DRDA. They have taken juniors to us to DRDA. We said you consider our case also. Why you left out the seniors?
But is it promotion?
No, it's deputation, my lord.
For promotion to the post of your.
Yes, my lord. It has been said to be a promotion because at that point of time they were thought that it was a promotion thing, but actually it's a deputation, my lord. But whatever the entire endeavor of this writ petition is that, my lord, there has to be a recruitment rule set in place for regulating regular promotion, my lord. That has not been done till now.
You see, once you don't challenge that, those appointments already made,
Which,
people who are already promoted, you'll have to say that their promotion was done in a pick and choose basis and.
my lord, on what basis my learned friend is saying that people are
I don't know,
already.
but he's made a point.
No, he is saying that there are 9 posts, cadre posts in rural engineering department. There is nothing has been, my lord, that those posts are filled up. How many posts vacant? It was a stand in the year 2022 that there were 9 posts, and from 2022, my friend is saying that posts are filled up. Fine.
You see, whenever we are hearing it,
Yes.
if there is an additional facts, you have to bring it on record.
Yes.
Yes.
As on date, the stand of the respondents is only available.
The
It
as on
is
date
not
stand of the respondent is that they are framing the rule. As on date, my lord. If lordships kindly take up page 9 of their affidavit, they say we are framing the rules. Para 21.
You see, rules is something which is another part. For the purpose of prayer number 2,
Yes. My lord, may I just simplify the thing, my lord. My lord, there is a channel for regular promotion to APO technical in rural engineering department. Cadre strength is 9. Now there is no rule.
then
And
where is the cadre notified?
my lord, It's, they have stated in the affidavit, I just point out, Milo.
There is strike, my lord. In the writ petition, it's a para 4, my lord,
Yes,
of the writ
No,
petition.
but what is the basis to say if there is no rules? How do you fix a cadre strength?
We have only the total, my lord, yes, we have not produced any record, my lord, but it is an admitted fact, my lord. We have the total strike of 9 costs
That's
of
how
APO
things
take, my
are.
lord, which is admitted by the petitioner themselves, my lord.
You can't go by that.
Yes, my lord.
You can't go by that.
My lord.
You have to, you see, when you have now understood the nature of grievance which is being raised by the
My lord,
petitioners.
yes, ma'am.
Correct.
Yes, ma'am.
Now he says that there are some people who are getting salary which is higher than them and they are junior in the
My lord,
cadre. There must be some rule to do that, to allow that.
my lord.
And if not, then when you are sending some people for deputation, knowing fully well that they will get a higher salary,
My lord.
then there's a right of everybody to be considered.
My lord. My lord, they had the right to challenge that at that point of time, my lord. Firstly, my lord. And secondly, my lord, my lord, going to the DRDA it was always a risk, my lord, because DRDA, they get salary after on like 3-4 months or 6 months, my lord. They will not get monthly salary because it is being, my lord, funded by central government and the state government, my lord. Not like a regular government employee, my lord. We
No, that is their problem.
yes, my lord. So who, my lord?
They are not solving that problem.
Yes, my lord.
So don't refer to that.
My lord.
Whether there is a risk or not is for the petitioners to take.
My lord.
But why will somebody not go if this given a higher salary in some place?
My lord, as per APO, as per the OAB of APORE, my lord, it is there, my lord. They are not paid, my lord, at our rooms, my lord. There's a government OAB, my lord. Over and above, my lord, we are paying as per the OM, my lord, set by the central government, my lord. We have only, my lord, taken that OM
How
from,
can somebody then get more?
my lord,
How can somebody get more?
my lord,
Can I give you a simple example?
my lord.
There are two standing counsel in the rural development department. One is getting 5,000 per case. One is getting 10,000 per case.
Well, my lord, can I say, my lord, can it be like one senior government advocate and one additional advocate general?
No, that is rank is different.
My lord.
So one is getting, that's okay. But in a department, there is a standing counsel. One gets 5,000, one gets 10,000.
Well, the scale of this,
Won't you say that there is a discrimination?
well, scale of DRDA, my lord, was always high, my lord. It was earlier, my lord, it was higher than the circle officers, my lord.
Please give equal opportunity to everyone. Article 14 stands violated.
Well, let them challenge this.
No, that is precisely challenge in the writ petition.
No,
Can you
no.
go through
It is
Second
not-
writ petition,
It is-
item 27.
Second writ petition, my lord, they are challenging the policy decision, my lord. The policy
Yes.
decision, my lord, central government, my lord, has, my lord, left the DRDA, my lord. Now, we cannot leave our employee as an orphan, my lord. So we have, my lord, absorbed them, my lord, in the state government. My lord. The cabinet has taken the decision, my lord. The state government has taken the decision.
Don't you feel that absorption without any rule is dangerous? How can you
We-
absorb
we-
someone?
we-
How can a deputation be, you have to repart.
We are formulating the recruitment rules now, my lord.
Again, same thing.
Yes.
In one side, you are saying that recruitment rules, the court cannot direct.
My lord, DRDA was guided by office memorandum issued by the, my lord, firstly by the central government, which we, my lord, followed by enacting it in our law, in our state, my lord.
You see, there's a picture.
My lord.
It depends on the nature of view we take.
My lord.
Once we say that even despite the power of the court not to issue directions to frame rules,
My lord.
but once we find out that there are disparity between the pay of two sets of employees, Article 14 is violated. What happens if we step down?
My lord, may-
There will be strikes and burns in your department immediately.
my lord.
It's a clear violation. Once you are giving poor protection to someone and you're sending some people.
No.
I like Mr. Saxena, I will send him there. I dislike you, I will not send you there.
my lord. No. So, my lord,
That's precisely what has happened.
they had the, my lord, the liberty to, my lord, challenge that appointment of private respondents or everyone, my lord.
You see, he's challenged it. I'm depending on Mr. Das. He's saying that in the second repetition, he's challenged that.
No, my lord,
And
he
we are
has
taking both
challenged,
we are taking both the repetitions together.
my lord, in that, my lord, in that second petition, my lord, we need some time, my lord. At least give us 2 weeks, we will file, my lord. We will file our affidavit, my lord. We are waiting for the cabinet. If cabinet does not take any decision, my lord, we will file our affidavit, my lord. Within 2 weeks, we will file, my lord.
2 weeks.
Yes, my lord. In that case, my
Okay.
lord. Otherwise, this, both the writ petition may be clubbed together, my lord, may be taken up, my lord,
No, fine.
after 2 weeks, my lord.
We are taking it together.
My lord.
That's why we were passing that order.
My lord. After 2 weeks, my
Milord,
lord.
to be very honest, Milord,
Next, just a moment. Next slide.
I'm sorry, Milord.
Uh, In this connection, the learned counsel for the petition has submitted that by filing WPC 390 AP of 2024, the petitioner has the petitioners have put to challenge
Page 32.
the notification dated 24/6/2024, by virtue of which the state is contemplating to include private respondents within 588 employees in DRDA to be absorbed in the Rural Development Department. And it is submitted that as few of the employees of DRDA are having pay protection from their absorption in the what is full form? You said that
Extension officer
extension-
within bracket
extension
rural
officer within
engineering.
bracket rural engineering result in disparity of pay in two sets of employees of the same cadre. And accordingly, the pay protection granted to those persons is also assailed in this said petition. Next paragraph. The Direct Standing Counsel for the Rural Development Department has submitted that as per instructions received by him, the matter is being examined by the authorities. And therefore he pays for 2 weeks time to file the affidavit by the authorities. Let's stop there. So, accordingly, the matter stands adjourned today. Just, Mr. Panchayat,
My lord, in fact, my lord can recall, my lord. This DRD were not getting 7 pay commission, but by the my lord, interference of your lordship only, my lord, they are getting, my lord, 7 pay commission. The DRD, my lord.
just, I would not remember that unless.
My lord. Yes, my lord has passed the judgment, my lord,
I would
in the
remember.
Nahalagan court.
In your this affidavit. What is you stated about absorption? I did not notice anything.
Absorption, my lord. My lord, they say
See, in paragraph 14. In
Hmm.
paragraph 14, you say that in case of absorption of DRDA employees in RD department,
Hmm.
the seniority will be fixed as per the laid norms and procedures.
Yes, my lord. So we are, my lord,
Where are those norms and procedures? Next, if be that as it may, in support of statement made in paragraph 14 of the affidavit in my position filed by the respondent numbers 1, 2, and 3, the said respondent shall produce documents where the norms and procedures applicable for absorption of DRDA employees are documented. We shall be produced on the next date of listing. Next date we'll give after some time, just we'll pass orders here also.
my lord.
But Mr. HK Das, Mr. D. Pichal, and standing also for the Rural Development Department. Next one. The learned standing counsel for the Rural Development Department has submitted that as per instructions received by him, the matter is being examined at the highest level of the department, and accordingly placed for him is granted 2 weeks time.
Right.
File affidavit in opposition in the matter. Next, now tell us a date. We fix it on 30 April.
30 April, my lord. Yes, my lord.
So that's
Fine, man. 30 April.
30
Fine.
April is okay. 30/4/2025. We are giving more than what you are wanting.
Yes, yes.
Lordship will kindly have a look, one page, just to understand, page 56 of item 27, my lord. What is the OM says and what they have done.
My lord, first
Page
May,
56, deputation terms. The initial term of deputation will be for 3 years, subject to review by the government from time to time on the performance of the deputationist or necessitating repatriation to the parent department. The deputationist shall not have any claim of their continuation on the plea that they will be downgraded on their repatriation in the parent department. The deputation should not be treated as a promotion. This is the fundamental principle of deputation. What they have done, they have absorbed them, given them pre-protection, first junior. I don't know what sort of policy they are following now, my lord, by virtue of the gazette notification. Absolutely contrary. They got 1,000 rupees there. We are getting 500 here. Give them 1,000 rupees. Tomorrow they'll give them seniority also. They'll above us. Strange procedure, my lord.
my lord, can it be on 1st of May, my lord, 30 April, my lord, I am 1st of May, my lord. Next day only. 1st of May.
My lord, 1st of May, some difficulty, my lord.
Second of May then.
Yes, ma'am.
2nd of May, my lord.
Yes, ma'am. 2nd of
2nd of
highly obliged.
May. Much obliged.
Your Lordship, I'm praying for adjournment in this matter, Your Lordship.
Why?
Because the standing counsel appointed by the Deputy Commissioner, Your Lordship, is absent today, Your Lordship.
My lord, in this, there is counsel appointed by the deputy commissioner who has filed their affidavit. My lord, that counsel is absent today. And land management department, we have not yet filed. It seems we'll require.
But this is a 2023 matter.
My lord,
If you're not filing, who is the authority to give you instructions? You have to direct them to be in your office.
my lord, earlier there was a standing counsel for land management. My lord,
Yes.
now we are taking over, my lord. So will
Who will be the authority to give you instructions?
the secretary,
Director Land Management,
secretary, director.
Secretary and Director.
Yes, ma'am.
Learn from the counsel to the petitioners present. Your name?
Odugo. Prisoner Odugo.
Odugo. Learn counsel to the petitioners present.
Yeah, let's see.
Next, the Mr. Endotel, and it Petitioner Advocate General have submitted that earlier the respondent number 1 and 2 was being represented by standing counsel for the department. Sorry, for the land management department. And recently, the said department cases are being handled by the government council. So accordingly, it takes for some time to obtain instructions and to file affidavit in opposition in the matter. Also, Mr. M. Katul on that DSGI correspondent number 4. 5. So who is 4 then?
What is deputy?
Also for,
4 and 5. So 4 and 5, okay. 4 and 5 present. Next paragraph. The respondent numbers 1 was filed the affidavit.
3 has filed.
Okay. Just next one say the respondent number 3 has already filed the affidavit in opposition. Next paragraph accordingly. The respondent numbers 1 and 2 will take note of the fact that that notice of motion was issued by order dated 25 January 2023, and in spite of several adjournments granted, the respondent numbers 1 and 2 have not filed their affidavit in opposition. So accordingly, the Secretary of the Commissioner, Land Management Department, within bracket respondent number 1, and the Director Land Management, within bracket respondent number 2, shall ensure that they provide due instructions to the runner. The Office of the Senior Government Advocate. Here, the establishment is called Office of the Advocate General, or it is the
Senior government advocate.
Senior Government, the establishment is Senior Government Advocate, so that in consultation with the Additional Advocate General, the affidavits should be can be filed within the extended time allowed. Thanks, Mala. In the event the affidavit in opposition is not filed within the expected time, court will be inclined to invoke the doctrine of non-purpose and presume that the respondent numbers 1 and 2 support the case of the petitioners. The appropriate orders will be passed thereafter. Next, the learned Mr. Very rank government advocate. Present along with the learned additional advocates and transmit download a copy of this order to the responding numbers 1 and 2. Next for our list. When?
Can it be after 4 weeks then?
Tell us a date, we fix it on that date.
13 May.
30, making it 14th.
14 May.
14 May 2025.
Yes.
May I apply to your last point? This matter relates to compassionate appointment. Pleading is complete, your lordship. But then last time we have taken time to file some additional affidavit. Because in this, in the first round of compassionate appointment, they have prepared the list. But then the juniors, they were appointed and then petitioner's case was not considered on the ground that she didn't appear when she was called, whereas she was not intimated when that appointment process was going on. So we have filed RTI to find out that who are the candidates who have been appointed, who are below the petitioners. So that's how we wanted to file that additional affidavit. But then we have not got yet information from the concerned department.
You want an adjournment?
Maybe 1 week time.
Mr. Provided on, let me comment if it is present. Next paragraph. Mr. Has more done for the petitioner. Raised for some more time to file additional affidavit in the matter. Additional affidavit.
Yes.
In the matter. So the matter stands adjourned today. List. You can't fix a date right
Yes.
now. And list after the ensuing due vacation.
Like obligation. 15 years, my lord. 15 also, my lord, it's related to the appointment of salary and allowance of members, consumer members, your lordship. They were appointed in 2023, but then they were not paid salary, especially as per the Consumer Protection Rule 2020. So now in this case, my lord, pleading was almost complete. But then we have not filed rejoinder. We are yet to file rejoinder is ready, my lord. Maybe
Either the pleadings are complete or not complete. It can't be almost complete.
not complete. Especially we wanted to file rejoinder, my lord.
You want to file rejoinder.
So maybe 1 or 2 days. Maybe 2 days it can be given 2 days.
It goes after vacation. We can't have it on these days. If both sides are represented. This is and an additional additional is present. As well on the prayer made by Mr. Esmond on counsel for the petitioner.
Pleading is it ready to be only to be signed by the petitioners?
2 weeks time is this is the matter after ensuing due vacation. It's to enable the petitioner to file affidavit in replying the matter.
No obligation.
Always.
Your lordship, earlier this matter was represented by the another council, and yesterday only we have been endorsed with this case here. And in the morning itself, we have filed the Wakalatnama along with the NOC here.
May I sign belt? Well, I am appearing for respondent number 1, 2, and 3, my lord. I am filing my affidavit today, my lord.
Your name?
In Roma, yes.
Huh?
In Roma.
M
In Roma.
and Chroma.
Yes, yours.
Current counsel has entered appearance for the petitioner and submits that he has filed a wakalatnama yesterday, which is not on record. Let this said affidavit be tagged with record. Next, Mr. Alpha and standing counsel for
Veterinary.
veterinary department. Raised for his granted. How much time?
Today I'm filing that.
Okay, submits that he's with the will be filing an affidavit in opposition in course of the day today. On behalf of respondent numbers
1, 2, and 3, madam.
1, 2, and 3. P. Sangeeta and government advocate appears for respondent number 4 and 5.
I'm appearing for 4 and 5. Your Worship, we have already filed our affidavit. We have filed our
You
affidavit.
filed. Oh, okay. Someone who submits that affidavit in opposition has been filed. List on. Make it next Wednesday. 9, 4, and 25.
Oblige.
Lordship, after serving for 30 years, I got retired on 3 June 2024. So still today, I am not getting my monthly pension.
Pension.
Yes. It's been about a year.
I did affidavit, no.
Yes, affidavits are filed by the Vigilance Department and the Pension Department. The only thing they are saying that there is a case pending against me. Investigation is pending. There is no law as such.
Where is that statement?
Lordship, in the affidavit of respondent number
2, your worship. 2, your worship. Yes.
2.
Paragraph 5, your worship.
But this issue, we have already passed some orders earlier that Vigilance Department cannot. What do you call the issue? The payment of pension will not be dependent on their no objection.
In a similar matter, Lordship, this honorable.
What is the date when you superannuated?
Lordship, 3 June 2024.
3
June 2024.
24.
Yes.
This vigilance department, no objection, I think there are some orders of the court.
Lordship,
For no objection of the vigilance department, is there, I think there's some order of the court.
no, Lordship, actually, the rule governing for the pension is in the CCS pension rules 1972. Rule 9 governs it, and Rule 9 never says that if there is any case is pending, investigation is pending, that the pension can be withheld. Rule 9 is very clear.
No, but this vigilance NOC is required, there is no OM.
Yes, there is OM,
Yes,
because
Where is that OM?
Article 300 is clear that there
is
should
that
be
OM?
law, and OM is not a law. OM is there, Lordship.
Who is that?
इसका मैं था
Annexure 5, Your Lordship, page number 36 of the writ petition.
32 to 39. Thirty-six is the type copy. This order has not taken assent of the governor also. Purely executive order. And here also, Lordship, if rule 7, sub-rule B1, 2, 3, 4 is to be seen, my case doesn't follow in this. Page number 36 is the type copy. Lordship, in this regard, our own apex court in 2013-12 SCC 210 in Jitendra Kumar Srivastava clearly stated.
For this vigilance, is there this order? Is there any order of this court?
No.
Page 32. Against that, there is no decision of this court.
Page 32 is the order, executive order of the Department of Vigilance. Here the procedures have been laid down. How to issue vigilance clearance certificate and whom to. My case doesn't fall in this category. Because here is clearly written, vigilance clearance shall be denied on the following. Number one, if NOC from the concerned deputy commissioner are not enclosed, government servants under suspension, government servants in respect of whom charge sheet has been issued in any disciplinary cases and disciplinary proceedings are pending, government servant in respect of whom prosecutions under PC Act and other criminal charges is granted. Only on these conditions, vigilance clear certificate can be denied. My case doesn't fall in any of these. In fact, our own High Court, in a similar situation case, in 2018, Judge Jambu Ratan was State of Arunachal Pradesh. The only allegation is that some FIR is pending. That is not only allegation that during my tenure, some irregular appointment were done. I'm not appointing authority, it is the director. During my tenure, because appointments are not made by the DDSC, it is made by the director.
No. There's an allegation that you sought for the approval from the director and you appointed. That is what led you into problem.
That is true, Lordship. That is a mere allegation. Investigation is still pending. My pension cannot be withheld on that ground. Apex code is clear. Article 300A is clear. And the rules governing the pension rules in CCS, rules 1972 is clear. Pension cannot be withheld. It's been 1 year, almost 1 year. I'm living a destitute life, Lordship.
Lordship, kindly see the Supreme Court judgment. Clearly covering my case. Paragraph 8, 11, 15, and 17. In another case, our own High Court.
You see, the problem is that when I ask you a question that is there any decision on the vigilance by this court, you said no. I asked the second time.
Vigilance only said in this
Asked for the
affidavit.
second time, you again said no. The problem is that the Guwahati High Court, the division bench has passed an order. Yes, Mr. Ram.
Yes, Your Lordship.
There's a division bench judgment of this court in Arunachal, state of Arunachal Pradesh versus AC Barwa.
Your Lordship, I'm afraid.
24/9/24 it was decided. This court has held that 9(2)(b) does not apply to criminal proceedings. And therefore, you can't stop the pension. Which is the CCS Central Service provision for pension, CCS pension rules?
1972.
What is the provision?
Rule 9. When can pension can be withheld? Here it says the president reserves, president here in for Arunachal Pradesh would be governor.
It's okay, Mr. Sana. Mr. Ram.
Yes, Your
It's
Lordship.
already a division bench judgment of this court.
Your Lordship, I don't have idea about the judgment, Your Lordship. I'm sorry.
Can I also see?
You should have seen before you came here. Last 2 or 3 paragraphs will show you. Last 2 or 3 paragraphs will give you the answer. In this case, during the pendency of the writ petition, they disburse the pension. Where is your pleading with regard to rule 9?
Lordship. Sorry, Lordship.
Where is your pleading with regard to rule 9?
CCS pension rules 1972.
Where have you pleaded that? Where is the pleading with regard to that?
Lots of this is rule. It's pleading. My only thing is that I have made representation twice before the department to release my pensionary benefits, monthly pension.
Your basic
That is
elementary pleading that the right would not have been deserved under rule 9. That's also not there. Better bring it on. Better bring that pleading on record.
so, that is because that is the law.
But it has to be pleaded when you are taking benefit of something.
My only contention here before the law, before this court that on prayer number 2, mandamus directing for issue of NOC. If they can't give NOC, then Lordship, there are laws which are clearly saying that my pension cannot be withheld only on ground that some case is pending. Because CCS rules doesn't say anything.
See,
Poems doesn't say anything.
unless things are pleaded, they may not be able to respond to it. That the requirement of no objection is contrary to rule 9. At least that's a basic pleading you have to make. I can't disturb that without. I can't even take the help of the division bench judgment and say that the procedure adopted is contrary to rule 9 because there is no pleading to it.
True,
They're
Lordship.
not given an opportunity.
True, Lordship. But the facts remain same. Facts
That you
remain
can't say that it's a law and therefore law is not required to be pleaded.
True, Lordship, but facts remain same. That there is no pending case against me, pending trial or even disciplinary proceeding is against me. There is nothing as such. So
Investigation
until
is-
and unless
investigation
there is
is
charge
there.
sheet.
Investigation is there.
Yes, only investigation
So
there.
one of the parameters of
It is
that
not the Lordship that I am on.
J. Venkatraman is available.
Lordship, one more thing here to be understood that.
I don't know, you want to make pleadings or don't want to make pleadings?
So if Lordship says that I have to incorporate.
No, I'm not saying it. It's for your wisdom. You must elect. You want to do it or don't want to do it. It's your choice.
Okay.
N. Janaki Raman.
What's
What's the decision? Supreme Court which says that criminal cases pending will.
That's N.K. Janaki Raman.
N.K. Janaki Raman.
I am on Jitendra Kumar Srivastava. Jitendra Kumar Srivastava. Here at paragraph 8, Lordship, it says it is an accepted position that gratuity and pension are not bounties. An employee earns these benefits by dint for his long, continuous, faithful, and unblemished service. Conceptually, it is also lucidly described in D.S. Lakara versus Union of India by D.A. Desai, who spoke for the bench in his immutable style in the following words. And further, Lordship, if paragraph 15, it clearly says, instead of West Bengal versus Harish G. Banerjee, the court recognized that even when after a repeal of Article 19(1)(f) and Article 331(1).
That's why we are asking you, have you done that pleading? You're not even challenged that notification. You're not even pleaded that the notification is contrary to the CCS rules. Tell us what do you want, what is your prayer?
My prayer is, my first prayer is mandamus directing the respondent authorities to issue NOC. And other third prayer is to release my monthly pension. It's been more than 10 months. There is no search and right, only mandamus.
Then we'll be dismissing this petition on the ground that there is an OM standing and that OM is not being challenged. Right. Mr. K. Saxena, and counsel for the petitioner. Also had Mr. Y. Ram Danar, government advocate appearing for the respondents.
1, 2, and 5, Your Lordship.
Respondent numbers 1, 2, and 5. Who is for the government advocate for?
I'm behalf of standing council education department.
Education.
For education department. 3. Who is for pension?
I am for pension. 5, Your Lordship. 5 also, sir.
Okay. Your name, please. Donald Council appearing on behalf of Mr. T. Tagum, Standing Council for Education Department, representing respondents for 3 and 4. Let's just take a short break and come back.
Read petition. It is pleaded. Paragraph 9. May I read, Lordship? That it is well settled principle of law that the right to receive pension is a constitutionally protected right under Article 300A of the Constitution of India. The Apex Court has time and again in catena of judgments has held that pensionary benefits constitute property rights and cannot be withheld arbitrarily. The Apex Court further observed that mere pendency of departmental or criminal proceedings cannot be a ground for withholding pensionary benefits unless a specific rule provides for such withholding. In the present case, the requirement of obtaining of no NOC or vigilance clearance from Vigilance Department, which is based solely on an executive order dated 25/20, does not have the force of law as contemplated under Article 300A. The Honorable Apex Court has categorically held that executive instructions in the absence of statutory backing cannot be considered as law within the meaning of Article 300A. Therefore, withholding the petitioner's pensionary benefits based on an executive order that lacks legal sanction is arbitrary and violates the petitioner's constitutional right to property. Thus, it is humbly submitted that this Honorable Court, while exercising its power under Article 236 of the Constitution of India, may direct the respondents to immediately release the petitioner's pensionary benefits, as there is no provision in the statutory rules authorizing such withholding under the present circumstances.
Okay, some trading is there. Okay. But next paragraph, I think this the case of the petitioner, in brief, is that he is superannuated on 31/5/2024 as Deputy Director of School Education from Government of Arunachal Pradesh. However, his pensionary benefits have not been released. Full stop. It is projected that prior to his superannuation, on 6/2/2024, SIC within bracket VIG bracket close PS case number 5 of 2024 under section 120 capital B. In 120, there is no bracket 120B. Yes. Oblique 420, oblique 409, oblique 468, oblique 471, IPC read with section 13 within bracket 2 of the Prevention of Corruption Act was registered. Wherein the petitioner is also one of the accused. However, the learned counsel for the petitioner has submitted that without Which provision is there? 9?
9, Rule 9 of CCS Pension Rules 1972. This rule deals with the withdrawal pension. Which rule is that? This is which year rule? This is 1972. 72 has been what do you call it, substituted by 2021. That is there. It is amended one. That is there in the book.
No, you retired in 2024. 72 will not be applicable
No,
to
no.
you.
Other one also.
No, no, no. Give me the correct law. Under Rule 8. Which bestows power on the competent authority to withhold or withdraw pension. On the strength of OM
€32. Page number 32.
Page number
32. It is class on 32.
The strength of
36 is the type copy.
order bearing number capital VIG -71 / 2014 / 365 dated 25/2/2020. The pensionary, the disbursement of the pensionary benefit has been withheld. First off. Yes. Projected that despite submission of representation dated 7/10/2024, the vigilance clearance was not given to the petitioner, and accordingly filing this writ petition under Article 226 of the Constitution of India. The petitioner has paid for a direction upon the state respondents to issue no objection certificate, public vigilance clearance in respect of the petitioner, as to enable his pension and other retirement benefits to be released. And for the prayers consequential thereto has also been made. Next one. Per contra, the learned government advocate has referred to the affidavit in opposition filed by the respondent number
2 and 5 units.
and as well as by respondent number 2. And it is submitted that the SIC within bracket vigilance, police investigating the matter relating to appointment of
MTS staff, Your Lordship.
PRT, TGT, and MTS.
huh?
PRT, TGT, and MTS.
No, there was a number 228 or 229 appointments, illegal appointments. There is a number.
Yes, number is there. 9 MTS. In second SIC vigilance PS case number 7. In 5 TGT and PRT. In 7, it's only 9 MTS.
No. Total 200 something appointments.
Affidavit of page number 46. Okay, so respondent number 2.
As per the report of the investigating officer, a total of 295 staff have been detected to have been illegally appointed under the Directorate of Elementary Education. And accordingly, their services were terminated. In respect of the petitioner, he is accused, he is investigated for appointing 9 multitasking staff within bracket MTS for short in his capacity as Deputy Director of School Education, ALO, AALO, without following the established recruitment procedures. And those illegally appointed 9 MTS and the service of the illegally appointed 9 MTS were terminated. Accordingly, comment is submitted that the authorities have rightly withheld the pensionary benefits from being disbursed to the petitioner. Stop. Accordingly, comment is submitted that the respondent authorities have not violated any rights of the petitioner, and under the circumstances, the withholding of the pension was justified. Next paragraph. The issue raised by the petitioner in this case appears to be squarely covered by the judgment order of the division bench of this court in the case of the state of Arunachal Pradesh and others versus Sri A. C. Barua. BARUH. WA number 7 of 2021, decided on 24/9/2024, and reported in within bracket 2024, bracket close 0 supreme, within bracket GAU, bracket closed 1284. Full stop. By the said judgment, comma, this court, by referring to the erstwhile provision of Rule 9 within bracket 2 within bracket small b of the Central Civil Services within bracket pension bracket close rules, comma 1972, has held that the said provision does not apply to criminal proceedings.
Lordship, small correction. Here in the AC Burwa case, AC Burwa's case, here at paragraph 27, it seems that there is a criminal proceeding is already initiated, criminal case. In our case, there is no criminal case, only investigation.
You are aware of it. Relevant paragraphs 27, 30 thereof is quoted below. Next paragraph. In this case, as There's nothing on record to show that charge sheet has been submitted against the petitioner and criminal trial has begun. In view of the ratio done by this court in the case of AC Barwa within bracket Supra. As the competent authority has not reserved his right to withhold the pension of the petitioner. The order number VIG-71/2014/365 dated 25/2/2020 shall not come in the way for the respondent authorities to release the pension and other retirement benefits to the petitioner to which he may be found due. Next one. How it is provided that the payment of pension to the petitioner would remain subject to any decision that may be taken by the competent authority under Rule 9 within bracket 1 of the CCS pension rules, 2021. No, not 9, it will be 8 now. 8. So where in the earlier paragraph when we said about Rule 9(1), then you added line that that it may be mentioned that the CCS within bracket pension bracket close rules on 1972 has since been substituted by the CCS within bracket pension bracket close rules, 2021, which has been notified in the Gazette of India on 20 December 2021, which will be applicable in the case of the petitioner as is superannuated on, what is the date?
31/5/2024.
31/5/2024. Then the rest of the now this will be last line will be 8(1). Next one. The competent authorities shall take a decision and release the pension to the petitioner within an outer period of 2 months from the date of receipt of certified copy of this order. Yes.
Disposable. Obliged. Maybe. But in this case, why did the last order not, a medical board was directed to be constituted? Because medical was the main ground for bail. My lord. Report should have been arrived, my lord, by what?
Bail on medical grounds.
Yes, sir. My lord.
We know, we've seen a politician in state of Bihar. He lived his entire sentence mostly in the hospital. Same thing, something like that here.
But I couldn't get.
There's a politician in Bihar, I forget the name.
Acha, acha.
All throughout his sentence, he remained in the hospital due to medical reasons. After being released, we have never seen him.
No, Lord, this is not that case. Actually.
No, not that case.
It's not like that. He was
Where-
actually airlifted from
Where is
Guwahati to Saket, Lord.
Where is the medical report?
On last occasion, register detective to do the needful lordship.
Huh?
It should have come through registry, Lord.
Doesn't take us anywhere. Look at this report.
We are inquired with the office. They said it has been received.
Like that. No, that flag, it doesn't take us anywhere. Look at this report.
Can I?
Yes, yes, definitely. It's not a secret. I think it should be taken to a government hospital. They will give it. Then it may be taken to a government hospital.
But then he can be examined here because now he has been discharged and he is on the recovery path. So
He's here now.
no, he's not here. He's still there because he is being asked to visit the hospital for one reason or the other. Like that.
But if
He's-
this report suggests otherwise, if he's discharged and he's well,
Lordships, I am for the complainant in this. There are multiple accused in this FIR who have sought this way of medical in Delhi. There are at least, the state will corroborate this, there are at least 2 accused who have sought either regular bail or anticipatory bail, and they have all come to Delhi, my lords, as if there is no medical facility in either Arunachal or any nearby place. This needs to be taken very seriously. 302 offense, my lords. Murder.
But if I'm allowed to submit on this count, Lord, which my friend is submitting, Lord, this is a case of utter misuse of the process of the criminal administration system, Lord. 13 members of the same family have been implicated and nothing has come out of record as on the date, Lord. And that's the reason this honorable court has been pleased to grant bail from time to time to the accused people in this case, Lord. And Lord, why I should be unlucky, Lord? If I go by my friends,
To provide anticipatory bail to everyone.
it's okay.
Because
you
there is
can
no
respond-
case against us.
You can respond when your turn comes. Every statement of the counsel for the petitioner may not be responded to.
I apologize.
Nothing has come out of record, Lord. If my lord will hear this case in a
Yes, we are hearing it.
detailed, Lord, then my lord will find that this process has been simply misused. You give the name of 13 people, whereas at this spot there were only two people. And you are implicating the members of the same family, Lord. This is that kind of case, Lord.
Where is the FIR?
FIR is at page 89 to 95, Lordship, Annex 5, or Annex 3, Lordship,
89.
89 to 95, Lordship.
'89, '95, Lord. No allegation against me, Lord, in that.
Lordship, allegation is at page number 95, Lordship.
Yes.
The second para, Lordship. It is known from the reverse source that the conspiracy waiting at late Lungya.
Is the case diary available?
No.
Case diary is available, Lord. It was ordered to be brought to this court, Lord.
No.
By-
Yes, there was not called for, Lordship.
No,
Only
by the first order itself, it was called. It was called by the first order itself. And then medical board were constituted.
We have called for the case diary. You have to close the case diary.
Yes.
There's an order on 28-2 for the case diary.
Yes, Lord. Yes, Lord.
It was first list only on 19, Lordship.
Pardon me?
No, 28th it was ordered.
No, there's an order of 28-2.
Yes, Lord.
You were directed to produce the case diary.
Correct.
Case diary has to be produced.
No,
Can
not receipt, Lordship. Yes, they did not receipt, Lordship.
Then get it. This is from which place? Which police station? East Coming District.
Yes.
We'll take it up next week. Get the case diary by then. Scan copy of the case diary. Give us a date. When can you produce? No, we are asking you.
After we have break, Lordship.
That will be too long.
Then we on the second week, Lordship, 10, 11, and then
After 15. You do one thing, you can just speak to the IO,
yes, Lordship.
ask him how voluminous it is.
Lordship, CD can be sent through WhatsApp also, Lordship. No, escape.
You just ask him, you just ask the IO how voluminous is the case diary.
Yes.
Then we will fix a date.
Yes.
How much time will it take to have this scan copy sent? Then we'll calculate and we'll give a date.
Is still asking, Lordship.
I think 15 days will be reasonable time.
10, Lordship.
Earlier also 15 days.
Fix it on the 10, Lordship. I will talk to the IO, Lordship.
10th.
Lord, for me, Lord, after 15th, if it is confirmed, Lord.
After 15, or
Within days of vacation.
what will reopen on
After
the
break, Lord.
Okay, then we fix it on 22nd of April.
My lord,
For the case diary.
22nd, I'm okay, my lord.
Lordships, I'm only requesting if the medical report says he's been discharged, my lords may kindly note it in the order. As a complainant, we don't have it. We have challenged the grant of regular bail in the Supreme Court.
No, I am myself going to submit to my lord that since now, after a prolonged hospitalization, I will be coming to my home. my lord.
Let me make it up, the essence of it, let me record it in the order. Okay. Your name, Mr.?
Abhimanyu Tiwari, my lords.
No.
Sushil Sharma, my lord.
Mr. Sharma, Learned Counsel for the petitioner. Also heard, Mr.
Deloy,
Learned ABP for the state, and
Okay.
Mr.
Abhimanyu Tiwari, my lords.
A. Tiwari, Learned Counsel for the complainant. Next one. Pursuant to order dated 19/3/2025, medical examination report from Max Healthcare dated 1/4/2025 has been received by the registry of this court. The relevant part of the said medical report is extracted herein below. This from here. Next one. It is observed that by earlier order dated 28/2/2025, the scanned copy of the case diary was called for. Mr. Learned AVP submits that the same is not received. Next paragraph. Accordingly, the Learned AVP shall obtain the scanned copy of the case diary from which police station? From the IO of Chayang Tajo, CHAYANG TAJO, PS case number 6 of 2024. So as to produce the same on the next date of listing. Next list on.
My lord, on the last date of hearing, my lord, can I submit, my lord?
Huh?
Can I submit, my lord? On the last date of hearing, my lord, it was ordered that my interim prayer for, my lord, will be considered today.
Let the case diary come, because without case diary, we can't.
Actually, now I'll be getting back home and, my lord, for recuperation, my lord.
No,
And
that's okay, but it's a 302, then without case diary, we can't give a bail.
No, I'm seeking interim, my lord, because interim only, my lord.
No.
He,
22/4/2025. Next, the Learned Counsel for the petitioner is at liberty to raise the prayer for interim bail on the next date of listing and on the date of case diary. You have to produce the case diary.
Yes.
You make a note.
22nd,
Write out that case diary, just say the next date of listing.
22nd, lord?
22nd.
22nd. Great. Great.
May I please, Lordship?
Yes.
Lordship, here, service reports, notice upon private respondent number 1 to 7 and 9 to 14 has already completed. But in respect of respondent number 8, that
Eight
is
is
still,
not-
yes. So it's
What is
been
the
a lot.
date when you took steps on respondent number 8?
Yes, Lordship.
When did you take that steps?
Yes, press steps, Lordship.
When did you take it?
Oh, Lordship, only it was the first day on after 22 up to 22 February 2024.
Okay, 28/2. It was
Yes.
taken. Okay. Then you have to take fresh steps.
Fresh step loss.
Okay. Mr. K. Lolan, counsel for the petitioner, has referred to the office note dated 3/4/2025, and it is submitted that except for respondent number 8, the notice is duly served on all the other respondents. All the other respondent numbers 1 to 7 and 9 to 14. So how none appears on call for the said respondents. Next para. As the service report in respect of respondent number 8 is not received, the petitioner shall take fresh steps for service of notice on respondent number 8. So take steps within 2 days for service of notice on respondent number 8 by registered post with AD. So the notice is made returnable on 7/5/2025. Next paragraph. The learned counsel for the petitioner is at liberty, shall obtain the postal receipt number from the registry and submit postal track report prior to the next date of listing. Next paragraph list on 7/5/2025. Give the track report, otherwise again it will be delayed.
Yes, so there is an interim audit.
Okay, interim order passed today, hence extended to the next date of listing.
Deeply applied.
You have not taken steps, who's for the petitioner? Nobody is there.
My lord, I'm appearing on behalf of private respondent number 5.
Oh, you are appearing. Okay, then no steps is required. Yes,
My lord, we'll file wakalat nama in due course and we'll file affidavit in the position also.
okay, your name?
T Taggu.
T
Taggu.
Tagum, TAGUM.
TAGGU.
Tagum. None appears on call for the petitioner. How Ms. P. Sangeeta and government advocate, as well as Mr. P. Tagud and counsel, has entered appearance for respondent number 5. And he submits that in the meanwhile he will file his wakalatnama. So he also prays for time to file his affidavit in opposition. Prayer is allowed. Yes, and the state is not filing affidavit.
Your Lordship, I'm appearing for 1 to 4 and we have already filed, Your Lordship.
You already filed, okay. Then comment advocate has submitted that an affidavit in opposition has already been filed on behalf of respondent numbers 3 and 4. Next, list the matter. How much time?
4 weeks.
We have it listed on 5th. 5/5/2025.
May.
Affidavit in opposition and wakalat shall be filed by the respondent of 5 by them.
Much obliged.
Obliged.
For the petitioner, your lordship.
May I please, Your Lordship? Your Lordship? Yes.
Yes.
This matter, Your Lordship, I am appearing for 1 and 2, Your Lordship. We have received our prior-wise comment for respondent number 1. However, for respondent number 2, Your Lordship, we need some time, Your Lordship.
You see, this is that defection law. If you delay the matter, then it becomes infructuous.
My lord, I'm
What-
appearing for respondent number 3 and I.
What is the tenure? What is the tenure of the Panchayat?
Panchayat, my lord, is in December, I think there will be election. In December,
December there will be election.
Your Lordship, we have received prior-wise from the Panchayat branch. We'll be filing it shortly.
How much time?
1 week time.
Next time. And you?
and I have already filed.
You have already
morning,
filed. Okay. All sides are represented.
Your lordship, there is an interim that may continue.
P. Sangeeta and Council Pradesh. No committed place for and is granted a week's time to file affidavit in opposition in the matter. Next para list on 23/4/2025. The affidavit shall be filed by them. Next para. Interim order passed release stands extended to the next date of this thing. Okay.
Oblige, your lordship.
Yes.
May I mention item number 28? This
28.
morning, madam, since the counsel for the petitioner is also Guwahati-based lawyer, madam.
Yes.
So, madam, here the department has instructed to, madam, instructed me to take some more time to file affidavit, madam. We have already sent the copy of the affidavit for vetting to the ministry, madam. 4 weeks time may be granted.
Just a moment.
Only to file affidavit, madam. This is promotion matter, madam. And quite apart from that, madam, the disciplinary proceeding is, madam, pending before the ministry, madam.
I beg to submit, my lord.
Yes. Yes.
My lord's order dated 20th January.
Yes.
Further, I beg to submit, my lord. Common proceedings started by order dated 2nd August 24, my lord. 3 of the alleged government servants, my lord, filed 2 writ petitions before Honorable Guwahati High Court, my lord. And the said writ petition was ordered on 20th November, staying the disciplinary proceedings, my lord. Subsequently, it came up on 5th of March, my lord. Stay continued, my lord. Then it came up on 25th of March. Stay continued, my lord. Because of non-filing of counter affidavit, the said cases to be taken up for exchange of pleadings in the month of May, my lord, as ordered by the Honorable Guwahati High Court.
What is the allegations against you? What is the departmental proceeding going on for?
My lord, departmental
Misconduct.
proceedings, it originated in the year 2020, my lord.
2020.
Yes, my lord.
What is
The
the
civ-
charges? Where do I get the charges against you? Where do I get the charges against you?
my lord, charges against me that I am the deploying officer of the casual paid laborer. There is a project in the Kargil known as Project Vijay, my lord. They recruit the casual paid laborer for border roads organization. Well, under the project, there is a task force known as 760 Task Force, my lord, commanded by Colonel Kaushik Mitra, who pays and disburses the casual paid laborers, my lord. Under him, there is a OC M.K. Jadhav, who filed the petition Randhir Kumar versus Union of India before the Honorable Guwahati High Court for the staying of disciplinary proceedings on the ground of vitiation of memorandum, non-compliance of Army Rule 180, in an inordinate delay. They got a stay, and stay still continued even by the order of 25th of March, my lord. My lord, the M.K. Jadhav, who is the OC who got a stay, under him, the two petitioner function as YC. M.K. Jadhav is the major rank officer, my lord. And these two petitioners, they are the rank of captain oblique assistant executive engineer, my lord. Aman Kumar and Amit Vekel, my lord. So,
Page number 53, my lord. Article of churches.
yes, sir.
Thank
So, my lord, this M.K. Jadhav, who before disbursing the pay, thought it wise, my lord, to check the names of the casual paid laborers who are working under his command.
Just a moment.
Just hand over to me.
Page 53.
My lord, all the Guwahati High Court interim orders I beg to submit to my lord for my lord's perusal. On the similar issue,
Okay, we'll continue at 2. We'll continue at 2.
My lord.
We'll continue at 2.
Settlement. Deeply obliged. With humility, my lord, I beg to submit a convenience note along with the judgment of Honorable Supreme Court in the matter of stay of charge sheet, my lord. If my lord permits, I beg to hand over, my lord.
It's already there.
Yes, my lord, the judgment of the Honorable Supreme Court is very vital, my lord, in the matter of staying the charge sheet. Para 9 is very relevant, my lord. This is a 2006 judgment, my lord. Para 9, my lord. I beg to draw my lord's attention, if my lord permits, to page 11, para 12.
Yes.
My lord, I have spelled out series of lapses in the matter of issuance of memoranda after inordinate delay of 4 years, my lord. When the cause of action happened sometime between 20th July to 21st August. That too also, my lord, the issue was names and father's name of the casual paid laborers, 18 in numbers, matched with the names and father's names of other unit under command of 763 BRTF, my lord, Border Road Task Force. My lord, there the commander was Colonel Kaushik Mitra. He also subjected to the Army Act, my lord. But unfortunately, my lord, he was given a simple warning and he was not brought in the court of inquiry, my lord. Even, my lord, I beg to submit. The medical officer.
We are not hearing on merit. Are we hearing on merit?
Okay. I bow.
We are
I bow.
asking for a prayer for interim relief. We have started.
I bow.
doing that.
I bow.
You concentrate on your prayer for interim relief. Concentrate on your prayer for interim relief.
Yes, my lord, I prayed, my lord. Page number 20, my lord.
Yes.
I read, my lord. While pending disposal of the case, your lordship may be restrained from giving effect of the impugned memorandum of charges board dated 2nd August 24, my lord. That is of common proceeding, issued by the Undersecretary to the Government of India, Ministry of Defence, against the petitioners, and not to resort any punitive actions in the matter of consideration for further promotion to the next higher rank, my lord. That is the executive engineer. This is my prayer, interim prayer, my lord. Yes. And my lord, the first petitioner has already been promoted by the President of India, my lord. Page 57. I beg to draw my lord's attention to page 57, my lord.
Here, his number is serial number 14, my lord. Serial number, my lord, though the memorandum is issued on 2nd of August, the promotion order was order issued on 10th of September. That is my humble submission, my lord.
You are reading which page? You are referring to which page? You are
57.
referring to which page?
57, my lord.
57. Yes.
Serial number 14, my lord. Petitioner number 1, my lord.
A, B, C, D, E.
Date order dated 10th September 24. The President of India is pleased to promote.
Page 57 is annexure H. Listen,
57, my lord.
yes, this is 57 in my book. Oh, this is doing this. This is.
My lord, I apologize if there is a wrong pagination in my lord's file. I deeply apologize. my
It's
lord.
okay. Try to get this correct one.
Here is my lord, I beg to apologize in my lord's
It's okay,
file.
it's okay.
60, my lord.
It's okay. Yes. Yes.
Page 60, my lord. And this is a presidential order, my lord. That he stands number 1, petitioner stands in serial number 14, my lord. My lord, the order is 10th of September. My lord, may kindly note, my lord.
Yes.
My lord, memorandum issued was 2nd of August 24, my lord. As I have sub, and my lord just educated us with the judgment of Honorable Supreme Court in KV Janaki Raman case. 3 parameters: suspended, disciplinary cases pending, criminal cases pending. My lord, my respectful submission that means knowingly DPC that the petitioner is charge sheeted. The DPC considered his name and promoted him to the next higher round of executive engineer, my lord. But my lord, unfortunate part is from the Director General Border Rows, my lord. I now, my lord's page number 58, my lord, where the posting cum promotion order, my lord, 2 pages order, my lord, of 12th September 24. Posting cum promotion order, my lord, it is heading, my lord.
Yes.
My lord, with deep regret, my lord, I submit that though he has been considered and promoted by the DPC,
Yes.
Director General Border Rows, who issued the posting order, my lord, dated 12th September. Though the promotion orders of 10th of September, he intentionally left out the name of the first petitioner.
which my lord was kind enough to note by my lord's order dated 21st of January and this honorable court order during the first date of hearing. My lord. Honorable Justice Haiku. My lord, if to support my stand, my lord, I draw my lord's kind attention to the seniority where the petitioner stand, my lord. That is, my lord, in my page, it is 61. It is a seniority list, my lord. Seniority list is a 10-15 pages, my lord.
Page number? What is your page number?
Seniority list.
What's that page number? Just again. 60?
It is there in my lord's file.
It's 61 in the brief. Okay.
My lord, the petitioner number 1. Stand in serial number 20, my lord.
What is his name?
Aman Kumar, my lord, petition number 1. His name was in the promotion order also, serial number 14, my lord. Promotion order dated 10th September, my lord.
Yes.
My lord, and petition number 2, my lord, in the same seniority list, my lord, he stands serial number 6, Amit Vekel. I draw my lord's kind attention to serial number 6.
Amit
Vekel, he is the petition number 2. My lord, his name had not at all been considered by DPC also. Just I beg to inform my lord for my lord's decision.
Yes.
My lord, last but not the least, I humbly submit that this being an army organization, my lord, the genesis of the memorandum, unlike the civil organization, my lord, is the court of inquiry. If the court of inquiry is vitiated, my lord, then the law laid down by Honorable Supreme Court and various High Court also stated that entire further proceeding also vitiated, my lord. I have cited the judgments of Honorable Supreme Court in my convenience note, my lord. Moreover, my lord, I have cited the reasons in the page 12 of my para 12 of my writ petition in seriatim. I have submitted why the memorandum should not be stayed.
Yes.
My lord, it is to the utter surprise of all the law-abiding people of the country, my lord, that, my lord, when the cause of action arose in 2020, my lord, in July, the first court of inquiry they initiated, my lord, in 24/11/20, my lord. I have cited the first court of inquiry. 24/11/20, my lord. July is so. Then what they did, my lord, that is Director General Border's office, they bore their additional court of inquiry after the lapse of 1.5 years, my lord. That is on 12th July 22, my lord. I have incorporated it also as annexure, my lord. My lord, then came the revised recommendation. I could not lay my hand on the recommendation, my lord. In the revised recommendation, it is on 5th of July 23, my lord. See how the suffering, I am subjected to dual punishment. My lord, then they 5th of July 23, my lord. I have incorporated the revised recommendation in the annexure also, my lord. Then, my lord, the memorandum are issued on 2nd August 24, my lord. That is 5th July 23. Then they took almost 1 year to issue memorandum of charges to me on 2nd August 24 in the guise of common proceedings. So, my lord, CVC guidelines, my lord, it says that when there is a unbecoming conduct, that should be investigated within 3 months' time, my lord. And if the charge sheet is to be served, that need to be served within 1 month time. So, my lord, to sum up, memorandum is vitiated. I have been subjected to the dual penalty. My promotion has been affected because of the belated submission of the memorandum. Had the memorandum been served sometime in the 2020, maybe I would have faced the penalty and completed the entire penalty period before my promotion was due. My lord, I am serving the country 36 years towards my service period, and only for 6 years I stayed station like Delhi and Pune. And rest of the period I served in the border roads, far-flung areas, my lord, in the northeast zone, Kargil and Leh, Ladakh, where the temperature, my lord, mortality rate is very high. Every month, 30 people die, my lord, in borderless organization. Because of the inhostile climate, my lord. Here, mostly I am engaged in the Indo-China border roads, my lord. In the far place. Still, my lord, only option, since I am putting on uniform, the rank, status, privileges matters not during the service, but after the service also. My lord, this is the humble submission, my lord.
Yes, Mr. Kato.
My lord, the issue is very limited, my lord, as instructed by the department. My lord, promotion order, if may I take your lordships to the promotion order once again, my lord. The contentions of the department is very simple, my lord. We are, my lord, even intended to give promotions to these officers, my lord. If lordship peruse again the page number 57 of the writ petition, my lord. I'm sorry, my lord. It is 10 September 2024, my lord, by which altogether 16 in numbers officers were promoted, my lord.
Page number?
Page number, my lord, I am having the copy of page, the writ petition, 57, my lord. Promotional order, my lord. I don't know, it is.
In my lord's case, it is 60. Promotion on order is 60. In my lord's file, it is 60. In my file.
Sometime it happens. Paging issue.
Yes.
Of 10th of
10
September.
September.
Yes. Correct.
That is 60.
Yes.
Yeah.
This is the presidential order, my lord, by which altogether 16 officers were promoted to the next higher post, my lord. My lord, I'll not read entire things. My lord, just below, my lord. Para 2, my lord. The name of the officers, the petitionary is at serial number 14. That lordship has already seen. My lord, second paragraph. DGBR may ensure that the officers recommended for promotion as mentioned above are clear from vigilance and disciplinary angle before placing them in higher grade, my lord. Now, my lord, these officers, lordship has already seen the article of charges. Unbecoming of, my lord, public servant, man. That imputation, man, allegation and the imputation against the officers is. Unless, man, these two documents, important documents are produced and these stages are cleared, the officers cannot be, man, promoted to the next higher grade, man. Petitioner is already, man, considered for promotion. Promotion has been given. Man, placing them in higher grade is the only issue before your lordship. Man. Now, man, unless these two conditions are fulfilled, man, officers cannot be, man, promoted to the next higher grade. Man. That is the, man, only issue. Man. Now, the counsel for the petitioner has pointed out this disciplinary proceeding has been stayed by the Honorable High Court at principal seat. Then, my lord, unless that is not, my lord, culminated into a, my lord, the fruitful result, that is the want of the documents, that is the, my lord, the end result which sought for by the department, my lord. Unless that is clear, the giving the officers to the next higher grade is, my lord, the lawfully, my lord, the impediment. Lawful impediment is, my lord, that he cannot be promoted to the next higher grade. Of course, promotion has been given, man. So therefore, disciplinary proceeding has to be done first, my lord. And the, my lord, another point, my lord, the point placed by the counsel for the petitioner is regarding, my lord, the court of inquiry, my lord. Exactly, my lord, they are, my lord, my just limited understanding, my lord. The court of inquiry is not, is because the order, presidential order by which, my lord, the disciplinary, my lord, the inquiry has to be conducted by the, my lord, the President of India, my lord. So therefore, it is not required to be placed them under, my lord, the court of inquiry. So therefore, my lord, one, my lord, of course, it is under, my lord, CCS
Not been able
rules.
to follow you. Not been able to follow you. What did you say?
My lord, the counsel for the petitioner has said them, this officer has to be done. The court of inquiry, my lord, by appointing court of, am I clear? It's good. Court of inquiry has to be done. Yes, my lord. But my lord, my submission is, of course, they comes under the Ministry of Defense. But in the Ministry of Defense, there are so many sections, man. These officers are basically meant for the construction workman, engineering background. But the other, man, the court of inquiry, regular court of inquiry conducted under the court of inquiry provisions, man, that is basically for the, man, the military, man, military personnel. Man. So therefore, this is not required, man. Somehow, man, still then, man, on 2nd August 2024, by presidential order, man, the article of charges has been framed against the officers, and the imputation has. So therefore, my lord, what, my lord, I'm bringing before your lordship is at least some more time may be granted. I'll come with the entire documents along with the affidavit, my lord. I'm sorry, my lord, this is the presidential order by which the court of inquiry, my lord, disciplinary proceeding has to be initiated against these officers. I'm sorry, my lord. My lord, para-wise reply, everything has been provided to the ministry for vetting. Only these two conditions are the, my lord, the difficulty whereby, my lord, his promotion to the next higher grade is not given. So therefore, once, my lord, the vigilance clearance are given, once, my lord, the is, my lord, culminated into some.
You can make a photocopy and give it to Mr. Das. You have only one copy. You make a.
I'm sorry, my lord, I'm having one copy.
No, it's okay. Give it to Mr. Das.
One of this is, I have incorporated with my writ petition. This is the memorandum of charges, which I beg to be stayed, my lord. That is the immediate prayer, my lord, which the Honorable High Court of Guwahati also pleased to stay in two writ petition, my lord. And last order is 25th of March, and next date given sometime in the May for exchange of pleadings, my lord.
Now, my lord, unless these two conditions, specifically, my lord, these two conditions are fulfilled, my lord, placing the officers to the next higher grade is, my lord, is not in compliance with the, my lord, the promotional order. That is the only, my lord, the whole failure. So, my lord, at this stage, my lord, may I pray, my lord, I've been given some more time to come with the, my lord, the affidavit duly vetted by the ministry. My lord.
Okay, one more question to both of you. In this bunch which the answers provided, WBC 4861 of 24 is one case.
And I'm sorry, madam, that part I'm not aware how and on what circumstances that has been considered.
That's okay. We are not saying about that. But once he's saying that there are another is Ram Narayan Chaudhary, WBC.
Yes,
19
two
or
petition
25.
clubbed with subsequently, my lord. Randhir Kumar and Ram Narayan Chaudhary.
They are taken up together.
Together subsequently, my lord.
Okay.
Initially, Randhir Chaudhary was there, which I have incorporated with my writ petition, my lord, and in my convenience note also, my lord.
Okay, so this will be the third case.
Same case, my lord, same and common proceeding.
This will be the third case, the third writ petition.
Well, in that case,
why we should not send this matter to the principal seat so that it can be taken up together?
Yes, madam.
If it arises of the same incident.
Yes, madam.
Mr.
No, madam,
Das,
if petitioner
to you
is
also and to Mr. Kato also. If all these three matters arise out of the same.
Yes, my lord.
Incident.
My lord,
same promotional order.
with due respect, I humbly pray, my lord. My lord, today, if my lord is pleased, then
No,
my lord can give the interim order
No,
of staying up.
That's another thing, but we are asking you, why could not be sent there?
Yes, my lord. That's my lord, that is a very acceptable direction from my lord.
But my lord, one thing, my lord, the petitioner thinks the order dated 10 September 2024, by which promotion has been given, my lord. The conditions.
No, why will he challenge it? He's saying that.
No, my lord.
Give effect to that.
Two conditions are given, my lord. The two conditions, para 2, as we have already seen, my lord, that condition is condition precedent, my lord. That cannot be, my lord, waived. Unless the documents are not being produced by the officers concerned, the promotions, my lord, giving and placing them in the next higher grade is not, my lord, as per this order, my lord.
My lord,
This is
that I humbly submit, that can be subject to the outcome of the disposal of the writ petition. A provisional promotion my lord may consider if my lord is pleased. But for today, my lord, I am begging for the interim order for the staying of the disciplinary proceeding, as it has been, my lord, in the Guwahati High Court, and my lord's directions or views in the matter of reference to the Guwahati High Court. I also do not have any objections, my lord. Okay. I have my humble submission.
Okay, I'll consider and pass orders. It will be released today. Examine the documents in the chambers and pass orders.
My lord.
Order is reserved, my lord.
No. It will be declared, but in the chambers, let me examine the documents and then pass orders.
Deeply obliged.
It will be released today. Maybe tomorrow it will be uploaded.
My lord.
By the time I give dictation, it will be late.
Tomorrow, my lord, if my lord permits, I want to leave at 12 o'clock.
No, tomorrow is otherwise court holiday. But uploading may take time. By the time I dictate, it will be too late.
Deeply obliged.
You may leave. It will be disposed of on today's date. This so not disposed of. In fact, the interim prayer for interim relief.
I will get deeply grateful if my interim prayer is.
That will be considered today. It will be pending matter. This is pending otherwise, it will status will be pending.
Lordship, in this matter, in the last occasion, we have filed an affidavit regarding the service to respondent number 5 via Dusty. No.
Where is the document of your settlement? Person? Where is the document of your settlement earlier?
Lordship, right now I don't have the files with me. The leading counsel is attending from Guwahati, and he is not present.
You see, there's a difficulty. We can't accept this. That's the service.
So the justice service was met with prior request, prior order by the court, honorable court.
No, that's okay. We don't, we are not saying that this was wrongly served. But this can't be accepted. Tell you the reasons why. First of all, see the last page. We put a flag, last page. Correct. You've seen the signature down below.
Yes, Lordship.
This is the signature
Of the
of the party. Yes. Now come to page 103. We put a flag there also.
Yes, Lordship.
So this is the signature on record. Visually does not tally. You take it by registered post. Your name?
A Gambe.
A
Gambe.
Gambe. Just mark it out. Mr. Gambi, your upcoming law, I'm just telling you, it's not for this case, but just for your skill. You see, a dusty service mode is normally civil in nature. So originates from the civil procedure code, where under order 409, the court may give the copy to the other to the petitioner to make service. Correct. But in criminal proceedings, dusty service is not prescribed. At least it's not to my knowledge. I may be wrong, but to my knowledge, it's not there. So to accept an affidavit of service in a criminal proceeding is something which you have to demonstrate, you have to show it to me. Correct? Yes. So the order of the court is okay, but to accept it, you must have some backing of some law for the timing in force. Either it can be under the criminal court rules and orders, or under the high court rules, or under the CRPC or BNSS, whatever. I've not come across, subject to correction by you, I've not come across dusty mode criminal proceeding. Correct? So that is my limitations of knowing law. But it is for this reason that I had done research. This signature tallied. They did not tally. It gave me a ground to issue a fresh notice. Correct? Under the criminal procedure code, under the civil high court rules and orders, the notice can be by two modes. Number one, by registered post, and second is by the jurisdictional magistrate. So if you want, you can give a direction for the alternative service also. It will go through the jurisdictional magistrate. This is high court rules. Which is Learned Counsel for the petitioner. Your name please, I forgot.
A Gamre.
E. Gamle, Learned Counsel for the petitioner. Next, Learned Counsel for the petitioner has submitted that pursuant to order dated 17/2/2025. The petitioner has served notice on the sole respondent by way of Dasti. And that an affidavit of service was filed on 11/3/2025. Next paragraph. Where is the service? Where is the notice? Which is purportedly it is projected to be accepted by the respondent. Next paragraph. On cursory examination of the signature of respondent available at page 103. Of the criminal petition. It visually appears that the signature of the respondent at page 103 does not tally with the signature which is projected to be service of notice on the respondent. So accordingly, court is unable to record its satisfaction of the notice being duly served on the respondent. Next paragraph. Accordingly, the petitioner is directed to take first steps for service of notice on the respondent by registered post with AD. So, 3 days time to take steps for service of notice on the respondent by way of Dasti. So not Dasti. Registered post with AD. For the learned counsel for the petitioner is that he is at liberty to collect the postal receipt number from the registry and to submit postal track report prior to the next date of listing. Next paragraph. In addition, to the postal steps, the petitioner shall also take usual steps for service of notice on the respondent through the jurisdictional magistrate. With due modification of the form of notice which is prescribed under appendix Roman 2 relating to criminal forms. In the usual notice, the notice of the date of appearance of the respondent shall be indicated as as 14/5/2025. So the next paragraph, the jurisdictional magistrate shall ensure that the service report is returned back to the court 2 days prior to the next date of listing. Next paragraph, list on 14/5/2025. I give 14/5 only. Again, 14/5/2025. You're giving you 3 days time to take steps. Plus loss. From the section Huh? Just take this. You also tell them that since I don't know which the address of the respondent is Pasighat. I do not know who will make the service in Pasighat. Because whether this Pasighat is CGM or judicial magistrate. But who has the control over process server? Means this notice which will go is under this form, but this will be modified. Magistrate, with due modification of this. We have our own process server, so it will not go through the district magistrate. Just tell them.
Highly obliged.
Because if my order is to be modified by the jurisdictional magistrate or district judge, then I have to write it as session judge in the order.
Your Lordship, I'm on behalf of.
Yes, you better pray for adjournment. We have.
Yes,
you have noted that.
Your Lordship, you have taken consent from all the.
No, that's okay. We're not on that. What is happening is that this matter is relating to APPSC is there. That's why we just wanted to see what the matter is about. One side it is APPSC and the other side is the Information Commission. Just wanted to see what is the matter about. We'll adjourn it, don't worry.
Yes, Lord.
I must understand what I'm doing. With consent of the other side, the learned counsel, you are for the petitioner.
No, Your Lordship, respondent number 2.
Okay, the counsel for respondent to place for adjournment. Where is allowed? Is the matter after?
BU break, Your Lordship.
After BU vacation. Okay.
Oblige, Your Lordship.
May I, Lordship? Lordship, I'm for petitioner and I may allow to make some clarification regarding previous order.
Yes.
Lordship, in previous order is mentioned that the interim order passed by the Superintendent CGS ST Daporizo, but a different authority being the Superintendent CGS ST Itanagar Range, Narlagan District, Pakumbara has been made as party.
Yes.
In this regard, Lordship, Superintendent Daporizo is reflected only on basis of a place of business where petitioner own his business.
Okay.
And kindly Lordship come to page number 27 of my petition.
Yes.
In
there.
left bottom corner, it is clearly mentioned that place Itanagar range.
Okay.
And Lordship, I am submitting some supporting documents regarding under Itanagar range, which of the following districts are being covered? In this Lordship, it's been clearly seen that under Itanagar range, Papumpare, Kurumkume, Karadari, Lower Subansiri, and Upward Subansiri have been covered.
Okay.
So there is no superintendent Dapurizo. It's superintendent Itanagar range. And Lordship, yesterday I have been spoke with superintendent and same has been clarified by him.
Okay. You're saying that this superintendent Daporije is not there.
Yes, Lordship.
Now it will be Itanagar.
Yes. In this regard, Lordship, course title is correct.
Is correct.
Yes, Lordship.
Okay.
My lord, I'm appearing for respondent number 2 and 3, my lord.
Yes.
Yes, my lord. Well,
Is
yeah, clarification, he's correct, my lord.
No, it's okay. Nobody said.
Yeah, it's okay, my lord. He's correct.
It's only when we are signing the orders, when we check, we don't find it. Correct. These things always bring to the notice of the court. Unnecessary troubles are avoided.
My lord.
Okay. Yesterday we passed an order. That is, we just there will be an addition in the order that although the order for cancellation of registration was passed by the superintendent of GST, Daporijo, but at present, the Itanagar division, Itanagar range. Itanagar range has jurisdiction over the area covered by the districts of Papumpare, Kurumkume, Krad Dadi, Lower Subansiri, and Upper Subansiri of state of Arunachal Pradesh. So therefore, the establishment of the petitioner, being situated at Daporijo, which is under Upper Subansiri district, the authorities was now required to do the needful would be the superintendent, Itanagar range. So it is also submitted that in the order of cancellation of registration, although the superintendent Daporijo is mentioned, the place where the order of cancellation was generated is generated on 27/5/2023 is shown as Itanagar range. That clarification will come. I'll show you where to make that. And the first line you say that heard. What is your name? Your name?
T Dodung.
T
Dodung.
Dogung, D-U-N-G,
Yes.
the counsel for the petitioner. Mr. M.K. Boru, and standing counsel for the first Union of India, Mr. Tato, the DSGA, and Mr. M.K. Boru, and the counsel appearing for respondent number 2.
2 and 3, my lord.
2 and 3.
My lord.
Next paragraph. The matter was listed on 2/4/2025. However, on the ground that the impugn order was passed by the superintendent of CGST, Dapuri Jo, the superintendent CGST, Itanagar range was read as respondent number 3, the order, which was issued on 2/4/2025, was recorded at the time when the transcription of the dictation was being checked. Next paragraph. The matter has been brought on board today by way of mention being made by the Learned Counsel for the petitioner. Now that it is submitted that. After that, the earlier order will come. Okay.
Deeply obliged.
Highly obliged, my lord.
May I meld? My lord, I beg to veto, my lord, in that case, my lord, liberty, my lord.
Why you want a liberty?
My lord, there are so many, while I filed these so many documents are not available to me, my lord. Now that's all documents
It's a
available.
lack of documents. Okay. So, Mr. Kalpamit, under counsel for the petitioner, upon instructions, I submitted that several documents were left out when this petition was filed. And accordingly, he has instructions to withdraw this petition and to approach the court again. Next, why the grounds are and government advocate is present. Next, it is considered and allowed. Was dismissed on withdrawal with liberty as paid for.
High level, sir.
Okay.
What is this? Okay, that's all.
Yeah.